The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, I'm Kevin O'Flaherty. I hope you enjoyed this Learn About Law video and podcast presented by O'Flaherty Law. If you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several locations for your convenience. Thank you so much for watching and listening.
Hi, this is Andrew with Learn About Law, and in today's video we're going to talk about involuntary bankruptcy, which is a legal process by which creditors can force an individual or business to enter into bankruptcy. The creditor must petition the courts to initiate the bankruptcy proceedings, and the indebted party can file an objection to force a case. Having this option gives creditors some degree of protection against individuals or businesses who may otherwise take advantage of the business. Involuntary bankruptcy is different from traditional bankruptcy, where an individual or business is either unable to pay their debt at all due to poor cash flow, or debt continues to accumulate at a rate that is impossible to reverse due to the debtor's financial situation. Traditional bankruptcy, such as Chapter 7 or Chapter 13, allows the individual to wipe the debt slate clean while giving creditors the opportunity to collect on some portion of the debt. Often, involuntary bankruptcy is brought against a business because the creditor feels the business is able to pay its debt but refuses, or has enough assets to liquidate that would satisfy the debt. Ultimately, creditors want to get paid, so forcing bankruptcy onto an individual or small fledgling company can be a bad move, tying up the creditor's legal resources in a process that likely won't net them much reimbursement. This is why involuntary bankruptcy is usually only brought forward against a business with assets, or in some cases a wealthy individual. If it's determined the business or individual doesn't own much or has limited income cash flow, then the creditor is better off collecting what it can outside of bankruptcy. The first step in involuntary bankruptcy process is when the creditor files a petition with the bankruptcy court. The petition lays out the requirements to be satisfied by the creditor and indicates whether the creditor is seeking Chapter 7 or Chapter 11 bankruptcy. Chapter 12 and 13 bankruptcy are not options under involuntary bankruptcy. The petition must list the reasons for initiating the involuntary bankruptcy. These are going to be things such as the debtor has failed over whatever period of time to pay debts as they come due, another entity took control of the debtor's property to force a lien, or the creditor holds a claim against the debtor that is not contingent as to liability and is in the amount of $16,750 or more. Depending on the number of qualifying creditors, the involuntary bankruptcy petition can be brought against the debtor by one creditor unless you've got three or more, and those have to be in agreement. If the debtor responds to the petition, there will be hearing and the court will decide if the bankruptcy moves forward. The judge presiding over the case will either rule in favor of the debtor, dismissing the bankruptcy and sometimes ordering the creditor to pay for the debtor's costs and fees, or ruling in favor of the creditor, allowing the involuntary bankruptcy to proceed. The debtor has 21 days to respond to the involuntary bankruptcy petition. Failing to respond will result in the bankruptcy proceedings moving forward, where an order of relief is entered and the debtor is placed into whatever bankruptcy was indicated by the creditor or that which the court deems appropriate. If you feel your business has a legitimate claim for involuntary bankruptcy against an individual or another company, or you're the target of an involuntary bankruptcy claim, don't hesitate to give us a call at 630-324-6666 and speak with one of our qualified bankruptcy attorneys. As always, thanks for tuning in.
Hi, Kevin O'Flaherty again from O'Flaherty Law. Hope you enjoyed our presentation of Learn About Law. If you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.